Hello and welcome. I'm Lucy Walker and I'm a financial services regulatory expert here at Guildhall Chambers in Bristol, and one of my particular specialisms is the Consumer Credit Act. That means I've been advising clients in the motor finance sector for many years. This is the second of two webinars that I've recently released. The first was on the topic of reform of the Consumer Credit Act, a process that is now well underway. And that webinar, along with this one, will be available on the Guildhall Chambers YouTube channel. This webinar addresses the topic of Motor Finance Commission and the non-disclosure of those commissions and the fallout from the proposed FCA redress scheme. Thousands and thousands of articles have probably been written about the Motor Finance Commission disclosure saga, and probably hundreds of hours of webinars have been put together on this topic as well. Therefore, the challenge when putting together this webinar was really to find something new to say or to find a different perspective on the whole saga. As luck would have it, there have actually been some very recent developments arising out of the legal challenges to the FCA redress scheme, and this has introduced fresh uncertainty as to the implementation of the scheme and the timetable for when the scheme might come into effect. Therefore, what I propose to do in this webinar is to look at the latest position regarding the FCA redress scheme and the nature and the practical implications of the challenges to that scheme, and how the timetable for implementation and firms' preparation for the scheme may be affected. However, I mentioned a few moments ago that I also wanted to find a different perspective on this whole saga. One of the interesting byproducts that's come out of all of this is the way in which the Motor Finance Commission disclosure scandal has exposed the behaviour of claims management companies when they're trying to attract customers and sign them up for claims for compensation. Claims management is, of course, a regulated activity under the Financial Services and Markets Act, and claims management companies are regulated by the Financial Conduct Authority. The response of the FCA to the behaviour of some claims management companies has been quite robust. And so I will spend some time looking at the activities of these companies and the behaviour that has prompted FCA action. In tune with that examination, I'll also consider the possibility of legal action by lenders against claims management companies for bringing spurious claims. The door has been left ajar on this possibility in the case of Vanquis Bank and TMS Legal. Anyway, let's rewind and remind ourselves of why Motor Finance Commission became such a big issue. The story actually began many years ago and concerns the way in which motor dealers were remunerated, i.e. paid commission, for introducing customers to lenders in order to finance the purchase by the customer of the car that they'd wished to buy from the motor dealer. Commission arrangement in widespread use, in historic terms, was the discretionary commission arrangement, a variant of which was the difference in charge commission model. What this actually meant in practice was that the commission paid to the motor finance dealer was linked to the interest rate that was set under the customer's finance agreement. Effectively, this incentivized the dealer to sell the customer a higher interest rate under their finance agreement, because a higher interest rate could result in a higher commission for the dealer. The concern was that customers were often unaware of the existence or effect of these commissions and could not make properly informed decisions about the finance being offered and whether or not to enter into the finance agreement. Frankly, it's a topic for another webinar, or indeed a series of webinars, as to the extent to which tangible, widespread consumer harm was actually caused by these failures to disclose commission. Yes, a customer might have got their finance a bit more cheaply had they known. They might have negotiated a little harder or shopped around. But unlike in the PPI scandal, in the vast majority of these motor finance cases, the customer drove away with the vehicle they wanted at a monthly repayment with which they were content. Anyway, I'm not proposing to disappear down that rabbit hole, as we could be here for hours and there are other things to talk about. Anyway, to get back to the main story, the FCA banned discretionary commission arrangements in motor finance from 2021. However, the live question before us contains the retrospective nature of that ban and what should happen where historic agreements, going back literally decades, involved undisclosed or inadequately disclosed commissions. Unsurprisingly, against this background, claims against motor finance lenders began to proliferate based on the tort of bribery, accessory liability for inducing a breach of fiduciary duty, and using the unfair relationships provisions of the Consumer Credit Act. And of course, these cases began to work their way through to the higher courts. In 2024, the Court of Appeal's approach caused panic and near meltdown in the motor finance industry when the court determined that a motor dealer owed a fiduciary duty to the customer when helping the customer to obtain finance for their vehicle. And of course, this resulted in the possibility of liability for bribery and accessory liability visited upon the motor finance lenders. Fortunately, in summer 2025, the Supreme Court handed down a much more sensible judgment and heralded a return to common sense. The Supreme Court held that in a typical motor finance transaction, the motor dealer was not the fiduciary of the customer. However, that Supreme Court judgment was not unalloyed sunshine for motor finance lenders, and in fact, the judgment opened up a broad new route for customers to bring claims against motor finance lenders by asserting that an unfair relationship had arisen between customer and lender for the purposes of Section 140A of the Consumer Credit Act. The Supreme Court held that unfairness may depend on a range of factors, including the size of the commission, whether it was disclosed, the extent to which it was disclosed, the way documentation was presented, and the existence of any undisclosed commercial ties between the motor dealer and the finance house. I'd ask you to hold those issues relating to unfair relationships in your mind for when we talk about the activities of claims management companies a little later on. Recognising that motor finance commission cases had the potential to become the new PPI, with millions of cases clogging up county courts up and down the land for years on end, and banks and lenders constantly having to make fresh provision in their accounts for redress claims, and of course the economic harm that that could bring, the FCA and HM Treasury at the highest level decided that intervention was necessary, and they attempted to introduce some certainty both as to timetable and redress, which was set out in the FCA redress scheme. This was obviously preferable to industry than millions of individual complaints and claims being brought through the county courts. Again, hold that thought in the context of the activities of the claims management companies. So, following various consultations, in March 2026, the FCA published its final policy statement, setting out the parameters and requirements of the redress scheme, And of course, the FCA has statutory powers under Section 404 of the Financial Services and Markets Act to implement a scheme of this nature. The scheme is intended to compensate customers who, between April 2007 and November 2024, entered into a regulated credit agreement, usually a conditional sale or hire purchase agreement, to finance the purchase of a motor vehicle. A motor vehicle for these purposes takes the same meaning as it does in the Road Traffic Act. Eligibility criteria apply, and the type of commission and disclosure arrangements must also meet the criteria set out in that final policy statement. It has to be admitted that the final scheme is actually narrower than that initially proposed through the various consultation papers. In a briefing to market analysts in the motor finance sector on the 30th of March this year, the FCA said that around 12.1 million agreements are now expected to be eligible, reduced from the first consultation estimate of 14.2 million agreements. Estimated redress is anticipated to be around £7.5 billion, with the total industry cost, once operational costs are counted in, estimated at around £9.1 billion. So this is still going to be a pretty hefty hit to the motor finance lending sector. There are several key features to emphasise. The time period, April 2007 to November 2024, recognising that supervisory responsibility changed from the Office of Fair Trading to the FCA as far as consumer credit is concerned, partway through the relevant timescale, supervisory responsibility transferred in 2014, the FCA has separated the earlier and later periods in its proposed redress scheme, and agreements will be differentiated accordingly. The eligibility rules have been tightened, and the concept of high commission and disclosure remains central to the scheme. The scheme focuses on arrangements where the commission, non-disclosure or broker-lender relationship may have made the customer finance house relationship unfair. Nevertheless, the FCA has reduced caps and methodology adjustments so that consumers are not placed in a better position than if they had been treated fairly in the first place. Therefore, redress is not intended to overcompensate consumers. On this basis, the FCA's figures on their consumer information pages suggest an average redress scheme payout will be around £830 per eligible agreement, although of course individual outcomes may vary. The scheme is intended to be firm-led. What this means is that lenders are expected to identify the relevant complaints and eligible agreements, and to obtain and analyse data relating to their commission payment arrangements, and look at the way in which those commissions were disclosed, assess eligibility, calculate redress, and communicate outcomes. This is an important feature because the FCA's clear objective here is that consumers should not need to instruct claims management companies or lawyers in order to be eligible for the redress scheme and to receive compensation. This has been all over FCA communications about motor finance commission. And again, I'd ask you to hold that thought when we talk about the activities of claims management companies. So, moving on to the challenges, the FCA confirmed in May 2026 that the redress scheme, i.e. the scheme that had been finalised in March this year, had been challenged in the upper tribunal. The FCA obviously has stated that it's going to robustly defend the scheme, but 4 applicants have applied to the upper tribunal, including Consumer Voice, represented by CMCs Legal, Volkswagen Financial Services, Mercedes-Benz Financial Services, and Crédit Agricole Auto Finance. I think it's interesting that the lenders in the original litigation that went to the Court of Appeal and the Supreme Court, Close Brothers and Motor Novo, and also Black Horse, which is part of Lloyd's banking group and another major player in the car finance sector, none of those players have put in a challenge to the redress scheme. It probably doesn't take a genius to guess that pragmatic, hard commercial decisions were made by those lenders, essentially to take the FCA scheme on the chin in the interests of a certain timetable and the ability to make provision for redress in their accounts with reasonable accuracy. The challenges are based on a variety of grounds. Some of them are distinct to the particular applicants and some of which overlap between them. By way of kind of a high-level summary, the following aspects have been challenged by at least one of the applicants, and these will be the issues that the upper tribunal will need to resolve. First is the FCA's power to make the rules in the first place and its approach to identifying consumers' losses in deciding that it has that power. The other big hot potato or very contentious issue is the application of the scheme to agreements entered into before the 1st of April 2014. I mentioned earlier that prior to that date, supervisory and regulatory responsibility for the Consumer Credit Act lay with the Office of Fair Trading and not the Financial Conduct Authority. The other aspect of the scheme that's being challenged is the FCA's application of the law relating to limitation periods, which affects the question of whether consumers have suffered loss or damage for which compensation is payable, or whether perhaps their claim is statute barred. Other challenges relate to the rules determining whether lenders are liable and whether consumers suffered loss and damage, including rules requiring lenders to presume that there was an unfair relationship between lender and consumer wherever a relevant commission arrangement was not adequately disclosed, and whether there was an unfair relationship between lender and consumer that actually was causative of loss and damage to that consumer. Challenges also relate to the calculation of redress, including the rules for estimating consumer losses by adjusting the annual percentage rate that they actually paid under their finance agreement. Also, the compensatory interest rate and the FCA's calculation and consideration of consumers' actual losses are also subject to challenge. Finally, there's also an allegation of unlawful interference with lenders' property rights under the Human Rights Act 1988, and that will also be another interesting ground of challenge for the upper tribunal to grapple with. Anyway, as a result of these challenges that I've just summarised, the upper tribunal, following agreement between all the parties, has suspended certain aspects of the operation of the FCA's redress scheme. Now, the upper tribunal has confirmed that it will hear the case on either the 14th to the 18th of December this year, or between the 16th and the 26th of February next year. And the final dates will be decided, or rather depend on, whether any of the applicants apply for further expert opinion or disclosure of information, and of course whether those applications are successful. However, whether it's December this year or February next year, realistically we won't get judgment until well into 2027. Now, until that legal process concludes, lenders are relieved from the obligation of having to calculate or pay compensation to consumers who may be owed money under the scheme. And of course, if the scheme is upheld and judgment isn't appealed, then again payments under the scheme might start later on next year. But of course, if the scheme is overturned, or if it's perhaps quashed in whole or in part, then the FCA will have to decide what it's going to do, whether it needs to launch a fresh consultation, and so the challenges to the scheme simply operate to prolong the period of uncertainty for both lenders and consumers alike. The FCA's clear message to firms is to keep preparing, keep gathering data, continue with the types of work that will be needed to be undertaken by firms in all scenarios, and that includes identifying relevant complaints, relevant agreements, gathering commission and disclosure information, trying to obtain or extract information from relevant brokers and motor dealers, and trying to resolve duplication issues. However, the FCA has indicated that it will not, for the time being, require firms to communicate with customers, make payments, as I've already mentioned, or submit monthly reports in accordance with the original redress scheme timetable. Those elements are currently suspended. I mentioned at the top of this webinar that in addition to providing a general update, I wanted to find a different perspective when viewing the Motor Finance Commission disclosure saga. I think one of the interesting features about this whole story is the way in which it has exposed the behaviours and practices of claims management companies when seeking to sign up complainants for redress scheme claims. The other interesting feature is the extent to which the FCA has sought to clamp down on these behaviours, and it has been really quite robust in some of its actions and responses. Now, I'm sure you, like me, will have been absolutely bombarded on social media and other channels and outlets regarding the absolute bazillions that you're claimed to be owed in respect of undisclosed Motor Finance Commission. However, in response, one only has to look at the FCA press releases and activities from the last 12 months or so to see the way that it has been policing those kinds of advertisements and those kinds of claims. Going back to July last year, the FCA issued a joint statement with the Solicitors Regulation Authority and sent a letter, a Dear CEO letter, to claims management companies setting out their concerns about the content of advertisements and the claims that were being made. On the 4th of February this year, the Solicitors Regulation Authority and the FCA issued a further joint warning to claims management companies and law firms involved in the Motor Finance Commission saga, and warned these firms to make sure that consumers don't have multiple representatives for the same claim, and also indicated that they were concerned about excessive termination fees. In other words, if a consumer decided that they didn't want to continue their claim with a claims management company, they had to pay an excessive exit fee in order to get out of their contract with the CMC. Significantly, at the end of March this year, a joint task force between the Financial Conduct Authority, the Solicitors Regulation Authority, the Information Commissioner's Office, and the Advertising Standards Authority was announced to tackle poor handling of motor finance claims by CMCs and law firms. And the behaviours that this task force identified as giving rise to these concerns and the formation of the task force was first multiple representation, i.e. consumers having been signed up with multiple CMCs relating to the same claim, and of course this results in uncertainty for firms and increased risk of unfair outcomes for consumers, including delayed or blocked redress claims. Misleading advertisements, misleading sign-up processes, including poor pre-contract disclosure, were also identified by the task force. Unsolicited direct marketing, high-pressure selling, the taking on of meritless and speculative claims, unreasonable exit fees, as I've already mentioned, unauthorised lead generation and misuse of consumer data, weak controls around client money and timely payouts, and disruptive behaviours that could delay redress to consumers. There were also concerns raised by the FCA about weak financial and operational resilience and the integrity of some CMCs, accounting and audit practices, also poor fraud controls and funding models that create incentives misaligned with consumers' best interests. So it was quite a long list of behaviours that gave rise to concern to the FCA and prompted the formation of this joint task force. All of this culminated again on the 6th of May this year, when the FCA announced, entirely separately to the formation of the task force, that it is launching a market review of the claims management market. And again, some of the concerns raised by the task force were repeated as prompting the market review, including the notion that customers were being signed up by claims management companies without their consent. And again, one only has to look at the FCA press releases to see a whole series of claims where individual claims management companies have been identified by the FCA, and the FCA has indicated that it is taking enforcement action against these companies, including the Claims Protection Agency Limited and Consultation Claims Limited. An FCA news release on the 4th of June this year stated that the FCA has removed or amended over 1,000 misleading motor finance commission claim disclosure advertisements, and that more than 28,000 consumers have been able to exit their contracts free of charge following FCA warnings and intervention. So, it's quite a litany of bad behaviour here, and as we noted earlier in this webinar, it's very clear that both the FCA and the government, through the actions of the Treasury, are desperate to prevent motor finance claims becoming the new PPI, clogging up the county courts and forcing banks constantly to have to revise the provision that they need to make in their accounts for the redress scheme. However, the FCA, against all this background, has repeatedly warned in its communications about motor finance claims that lenders really don't need to resort to a CMC or a law firm in order to promulgate their claim. One of the key complaints from lenders' perspectives is that customers have been signed up by multiple CMCs with no concern or verification as to whether the claim is eligible, all already in the hands of another claims management company. And so lenders, quite understandably, anticipate a tsunami of duplicative or otherwise ineligible claims. Now, this leads me neatly to the case of Vanquis Bank and TMS Legal. By way of background, Vanquis brought proceedings against TMS, which was a law firm. Now, Vanquis is a bank that specialises in lending to individuals who may not have access to mainstream credit providers. TMS is a law firm that specialises in financial mis-selling complaints. And TMS operates on a no-win, no-fee basis, charging clients a percentage of the redress obtained for them. Now, Vanquis began to receive large numbers of claims from TMS relating to alleged irresponsible lending to its customers by Vanquis. And these complaints alleged that Vanquis failed to conduct adequate affordability checks before issuing or increasing credit limits for its customers. By August 2024, Vanquis Bank had received over 33,000 complaints from TMS. Vanquis's own analysis indicated that many of these complaints were either out of time, i.e. they were statute barred, or they totally lacked merit, or both. Of those complaints that had been escalated to the Financial Ombudsman Service, only 16% of those complaints were actually upheld by the Financial Ombudsman. Vanquis argued that all of these complaints submitted by TMS were submitted recklessly and indiscriminately and in breach of TMS's duties to its clients. Vanquis claimed losses of over 12 million, including financial ombudsman case fees and extra staffing and lost profits. Now, the interesting point about this is that Vanquis pleaded its case in tort and pleaded the tort of causing economic loss by unlawful means, claiming that TMS caused Vanquis significant financial loss by submitting large numbers of unmeritorious complaints. The tort has 4 elements: unlawful acts used against and independently actionable by a third party, interference with the actions of the third party in which the claimant has an economic interest, intention to cause loss to the claimant by the use of unlawful means, and loss caused to the claimant as a matter of fact. Applying those elements to the case in Vanquis and TMS, the court had no difficulty that TMS's breaches of contractual, fiduciary and regulatory duties to its clients could constitute unlawful means, and it was arguable that TMS's actions interfered with Vanquis's economic relationships with its customers. Vanquis had a plausible case that TMS acted with the requisite intent, and Vanquis had pleaded sufficient loss which may have been caused by TMS's actions. Now, before anyone gets too excited, the case of Vanquis and TMS was held in the context of an application for strikeout of the claim or reverse summary judgment by TMS. TMS argued that the tort of causing loss by economic means could not be used in this way or in this context. And so it's important to remember that this was a strikeout summary judgment application and that the case hasn't yet been fully argued before the court. Nevertheless, in that application, the court determined that Vanquis's claim should continue and that TMS's application for strikeout or reverse summary judgment was dismissed. Now, TMS appealed that judgment at the back end of last year, but was refused permission to appeal by the Court of Appeal, and therefore it looks like the case will continue in the High Court, unless, of course, it settles. However, this is the first time that the tort of causing economic loss by unlawful means has been used in this way, and so it's actually quite a novel case. But what I hope that you can all see by now, when set against the background of all the kerfuffle with the claims management companies and the market review and the identification of bad behaviours by the FCA, I hope you can all see the potential significance of the case of Vanquis Bank and TMS and the encouragement that it may bring to other lenders, particularly in the motor finance sector, if, as anticipated, these motor finance lenders receive the anticipated tsunami of duplicative and unmeritorious and statute-barred claims that they are currently expecting from CMCs. It seems to me that this is a potentially fruitful area, certainly fertile ground, for lenders to consider bringing claims against law firms and CMCs in the future. So, to conclude, the redress scheme remains one of the most significant consumer redress schemes in recent years. However, presently it is in, I suppose, suspended animation, pending the various legal challenges, and we won't really have a conclusion until at least 2027. In the meantime, practitioners may also wish to keep a close eye on proceedings in Vanquis Bank and TMS Legal, given the potential significance of this case in the context of claims management company activity. So that's it for now, but thank you very much for watching, And please do not hesitate to contact me or email me, or indeed my clerks, Jo State and Charlotte Blair, if you have any questions. Thanks very much.